The Civil Liability Convention. The International Convention on Civil Liability for Oil Pollution Damage, CLC, was adopted in 1969 to address the issue of liability and compensation for oil pollution caused by ships. Major pollution disasters like Torrey Canyon and Amoco Cadiz severely affected the livelihoods of fishing communities and those dependent on the tourism industry. The damage caused was enormous. It became important to establish a system that enables liability to be determined and ensures that compensation to the affected parties is paid. The main goals of the CLC Convention include establishing strict liability for shipowners, ensuring fair compensation for victims of pollution damage, and promoting international standards for oil pollution prevention. Strict liability means that shipowners are held liable for oil spills even without fault, with limited exceptions. The convention also mandates compulsory insurance for ships carrying oil, ensuring that funds are available for compensation. Owner means the person registered as the owner of the ship. In the case of a ship owned by a state and operated by a company, owner shall mean such company. Oil refers to any persistent hydrocarbon mineral oil such as crude oil, fuel oil, heavy diesel oil, and lubricating oil, whether carried on board as cargo or in the bunkers of such a ship. Persistent oil refers to petroleum-based oils that dissipate slowly in the environment and remain for a longer time after a spill. These oils typically have relatively high viscosity and include crude oil, fuel oil, and lubricating oil. Pollution damage means loss or damage caused outside the ship by contamination resulting from the escape or discharge of oil from the ship, wherever such escape or discharge may occur. Compensation for environmental impairment, other than loss of profit, is limited to the costs of reasonable loss or damage and measures of reinstatement actually undertaken or to be undertaken, the costs of preventive measures, and any further loss or damage caused by those preventive measures. The convention applies to pollution damage caused in the territory, including the territorial sea and exclusive economic zone, EEZ, of a contracting state, or as a result of preventive measures for oil pollution. No liability for pollution damage shall attach to the owner if he proves that the damage resulted from an act of war, hostilities, civil war, insurrection, or a natural phenomenon of an exceptional, inevitable, and irresistible character, or was wholly caused by an act with intent to cause damage by a third party, or was wholly caused by the negligence or other wrongful act of any government or other authority responsible for the maintenance of lights or other navigational aids in the exercise of that function. Compulsory insurance. Ships carrying more than 2,000 tons of oil as cargo are required to maintain insurance or other financial security to cover their potential liability under the CLC. Direct action. The CLC allows those who have suffered pollution damage to bring claims directly against the shipowner's insurer. Limits on liability. The CLC sets limits on the shipowner's liability based on the ship's tonnage. For example, the 1992 CLC sets a minimum limit of 4.51 million SDR, special drawing rights, B, for ships above 5,000 GT, 4.51 million SDR plus 631 SDR for each additional GT, with a maximum limit of 89.7 million SDR. Exclusions. The CLC does not apply to warships, naval auxiliaries, or other ships owned or operated by a state and used for non-commercial purposes. Time limit for claim. Claims must be made within 3 years from the date the damage occurred, and in no case later than 6 years from the date of the incident. Documents to be carried on board. Ships carrying more than 2,000 tons of oil are required to maintain valid insurance policy documents in accordance with the CLC Convention. Based on this document, the Flag Administration issue the certificate attesting that insurance or other financial security is in force in accordance with CLC. If the ship is not registered with a contracting state, this certificate may be issued by any other contracting state. Originals of both the policy documents and the certificates are to be maintained on board for verification by authorities. The 1992 Fund Convention, which is supplementary to CLC, establishes a regime for compensating victims when compensation under the CLC is inadequate, which is known as Fund Convention. Same will be explained in the next video. For more marine topics, please subscribe the channel. Please help us with your valuable feedback to improve the contents.